I'd like to welcome everybody and thank you so much for joining us this morning. It's a Sunday morning, and we are professionals in the area of family law, and we put this program together for women that are contemplating divorce. The actual title of the panel discussion is Cooperative Divorce, and that really is the focus that we all have in our practices. I just want to take a minute and explain why it is that we all decided to work together and do what we're doing, and also give you a sense of what we're hoping you're going to gain out of the couple hours you're going to spend with us this morning. All of us in various different professions around town work with divorcing couples all the time. Some of us much more so than others, but for the most part over the last few years we've gotten to the point where we recognize the level of contention that's involved for families in your traditional litigated divorce model, and we very, very close and personally have seen the devastation and the destructive impact that way of handling divorce has had on families. And in meeting with each other and talking, we all know each other, professionally and personally, we decided that we know that there are better ways out there to do this, but unfortunately most of the public does not know that there are better ways out there to do this. So our goal is to try to start to educate the community and change the dialogue and change the way we all think about and talk about divorce, in the hopes that maybe if we reach people early enough in the process, even when they're just starting to contemplate divorce, and maybe plant some seeds on some better ways to handle it, we can change the way we're all, as a community, dealing with divorce. I would say probably everybody in this room knows at least one other couple going through the process, if not yourself. Some of you are actually here to help friends that are going through the process. So I don't think there's anybody in town at this point that doesn't know somebody, whether it's a family or a close friend, that's gone through the divorce. And if you ask around, almost invariably everybody says, it was horrible, it was the worst experience of my life, it destroyed my family, and that's what we all together are trying to avoid. So I'm going to take a couple of minutes. I want each one of the panelists to introduce themselves and explain who they are and what it is they do. And then afterwards we're going to go around the panel again, and everybody's going to talk in much more detail about what it is, what services they provide for divorcing couples, and how those services can be used in a much more cooperative and peaceful context.
Okay, my name's Diana Kahn. I'm a certified financial planner, or CFP. I've been president of the Financial Pharmacist Incorporated since 1997, and what I do is I provide objective, fee-only financial advice for people in many situations, but one of the situations I specialize in is whether they're planning for divorce or are going through the process or have just gone through divorce, and I act as a mentor and a coach and a person to sit by and hold their hand as they go through the various other processes having to do with the legal and tax and so on implications of going through this entire process.
Bob?
Thank you. I'm Bob Merlin. I am an attorney. I'm board certified in Maryland family law. I limit my practice to family law, and I specialize in collaborative family law, which I will speak more about in a little while. It is a way of helping people get through the process without destroying each other. It's private, staying out of court, and as Denise said, I concluded that there had to be a better way than litigation. I have a lot of experience in litigation, and I really do not want to do it anymore, because there are better ways to do it. A past president of JCS on the board of Federation, and second generation Miamian, so I've been here for a long time.
Wow, second generation. I'm Judith Lieber. I'm a licensed psychotherapist. I'm a certified family mediator and a qualified parent coordinator. And I'm also the Vice President of Behavioral Health Services at Jewish Community Services. And we're really thrilled to be part of this panel and to talk about better ways to achieve a resolution of a divorce and to really protect the children so that everyone in the family can move to a new life and a new place. And that really is our purpose. I look forward to having that discussion with you.
Hi, my name is Denise Tamir, and I am formerly a litigator. I am still an attorney, but I've chosen, like Bob, not to continue to litigate for probably a lot of the same reasons, but in a different context as Bob. I was a litigator, and then I took a hiatus to raise my children, and when I was looking for what I really wanted to do when I came back to the workforce, I had a choice to make. I could go back into the practice of law and continue to litigate, or do something a little bit more peaceful. And I spent a lot of time in our community on various boards, and realized that you can come to compromise, you can come to consensus, and you can come to agreements in even the most bitter, contentious situations. So I decided to become a full-time mediator. I'm now a licensed circuit civil and family mediator. And I've decided to devote my entire practice to mediation first, and about 90% of my practice to mediation in family law. I believe that is the best place, or it's the best use of mediation skills. I mediate other things, foreclosures and insurance cases, but I really find that it has the most benefit in dispute resolution in the family context. Now that you've got to know a little bit about us, I think what we'll start with is Bob Merlin explaining a little bit more about the divorce process, what it is you need to do and the issues that you need to consider, and how his specialty, collaborative law, is a wonderful way of achieving those.
Great. So when I say I do family law, I mostly am intending to mean divorces, but it also deals with other things as well. I prepare prenuptial agreements, postnuptial agreements. I represent clients in same-sex partnership agreements, paternity actions, all sorts of things. But we're focused on divorce, although the collaborative process applies to all of those areas. Traditionally, if you were getting divorced, one party had to file a petition, that's a piece of paper in court, alleging certain minimal things so the court could have jurisdiction. The other party would file an answer, a written document responding to it, and maybe also asking for a divorce. And there would be a battle in court. You all may remember Arnie Becker from LA Law. That was the traditional model of the family attorney. It used to be that you wanted to hire the pit bull, you wanted to hire someone who was going to destroy your spouse. And there was no concept of the consequences of those actions on the other spouse, and certainly on the children. As time has gone on, there have been a lot of studies about the effect of conflict and stress on brain development of children, on the spouses themselves. And so I hate to use this term, but the intelligent professionals have concluded that there are better ways to do things. The reality is that 90% of cases filed wind up being settled and do not go to trial. There may be some hearings along the way, but in 90% of the cases there is going to be a settlement. The question is, how do you get to that settlement? How much does it cost? How long does it take? And what collateral damage is caused when you're getting there? In 1990, there was a gentleman named Stu Webb up in Wisconsin who just came to the conclusion that not only is there a better way to do it, I'm going to work on a way to create a better way to do it. So he contacted a judge in Minnesota and other professionals in his community, and they worked on creating a model. At the same time, there was a psychologist in California who was sort of coming up with a model to help couples get through the process without being in court. And the windup is that there is now the collaborative process, which basically involves each party hiring a specially trained attorney. The model we follow in Florida is also using a neutral mental health professional to help them get through the process, and when necessary, a neutral financial person such as Diana to deal with the financial issues. There are no battling experts. The process is completely out of the court system until the very end, when all that the court is asked to do is to approve the agreement that the parties have entered into. We pay very close attention to the welfare of the children. In fact, some of us ask our clients to bring photographs of their children, put them on the table to remind them as we meet that the focus is on the children, and don't forget the children and the welfare of the children. We meet together and negotiate together. I am not a threat to the other spouse, and I make it very clear to the other spouse that I'm not a threat to him or her. The professionals are there to facilitate the process, to help the parties control their own destiny, as opposed to the litigation model where if you do not agree with your spouse, what the settlement is going to be, a judge will dictate to you how you and your children are going to live the rest of your lives. We sign a contract that basically says we are going to be respectful of each other. We are going to voluntarily exchange all information. We are going to meet together to identify issues, discuss potential resolution of those issues. We will meet as many times as it takes. Usually it's about 4 meetings. The meetings usually take 2 hours apiece. There's an agenda for each meeting so that everybody knows in advance what the subjects are that are going to be discussed. Everybody usually has homework to do to prepare for the meetings, and we will move along until there is an agreement and it is submitted to the court. As I said, nothing is being filed in court as we go along. So if you are concerned about your privacy, this is the best way to go, because your neighbors don't even have to know that you have filed for divorce unless one of you tell them. When you file in court, the papers are public record. There are issues now about access to the courts because of identity theft, and the courts are going through a huge process, and it's an expensive process, of determining how people should be able to access court files, but you have to assume that anything filed in a court file is public record. That is not what happens in the collaborative process because we privately exchange documents. The contract that we sign also says that it's a voluntary process. Nobody can force you to do anything in the process. And if one of the parties wants to leave the process, the collaborative attorneys will not represent them in litigation. It means that the attorneys are absolutely dedicated to helping the parties resolve their case. The process is not going to break down because an attorney causes a problem, as frequently happens, unfortunately, in my profession. There are some attorneys who are known for causing more problems than they resolve. The goal is to help the parties get through the process, get to a place where they are, under the circumstances, in the best possible position they can be in. There may be very bad financial situations, emotional situations. We try to make the best of it, trying to give the tools to the parties so they can make the decision how they're going to live their lives and hopefully live a healthier life. We sort of, without discussing it, we have a model in mind where the parties are going to walk down the aisle with their children at their weddings. Instead of having only one person there, I have a friend a friend of my daughter's who's getting married in a few months. Her father's not going to be at the wedding. It was a very bad divorce, and it's a shame. It's a shunda, to be blunt, and we don't want that to happen. We want to help parties get to the best possible position they can be in. The collaborative process probably, but not guaranteed, will result in less money being spent on professionals. In the litigation model, typically, if there's wealth, both sides are going to hire forensic accountants, and you're going to have battling forensic accountants. In the collaborative process, there's one forensic accountant if one is needed, and so the cost there is just in half. In litigation, the attorneys really control the process, and we attorneys have a tendency to think that we're experts at everything and we can do everything, and it's very difficult for us to give up the control of the process. In the collaborative process, we utilize a Judith Lieber to deal with issues that are appropriate under the circumstances. I have a lot of years of experience in handling divorces, but I do not have the degree that Judith does, and I do not have the experiences that Judith does. So in the collaborative process, instead of attorneys working on a parenting plan, which is the agreement that must be, it's let's say contract, because it may not be by agreement, a court could dictate it, but the contract that's going to govern how the parents parent their children. In the litigation model, that's going to be done by the attorneys in most of the cases. So you have two attorneys charging anywhere from $250 to $700 an hour. So you're talking about $500 to $1,400 an hour to work on this document. In the collaborative process, the mental health professional works on that. The attorneys are out there sort of supervising, but they're not involved in the actual work on the document. And the mental health professional, one person with a better education for the issue, better experience on the issue, at a much lower hourly rate, is going to handle that issue of the parenting plan, and the parties are going to save a lot of money on that issue. One of the biggest problems that exists now in our system of the judiciary is how long it takes to get anything done. It's very bad in Florida because of the foreclosure problems. There is a dramatic lack of funding. There aren't enough judges, there aren't enough court staff. So to get into court, if you think you're going to go into court and fight and get something done quickly, you're going to be rudely awakened, and you're going to find that it takes a long time to get through the process. If I went tomorrow and was able to get into a judge to ask for a final hearing, a trial, it would be scheduled 6 months from now. And it takes probably at least 6 months just to get to the day when you are able to ask the judge for a final hearing. I have a case where all I'm asking the judge to do is schedule a hearing. It's like a half-hour hearing. I can't even get the judge to schedule a hearing, let alone when it's going to be. And this is what is happening in the judicial system. In the collaborative process, that does not happen because we schedule things regularly, we move the matter along. The process will move as fast as the slowest person involved, but chances are it's going to move much faster than being in court. We feel that it is a much healthier process. It is very successful. The statistics around the world is that the cases that start collaboratively end collaboratively 90% of the time. The process has moved from Minnesota, where it started, to all over the world. I just attended last week the International Academy of Collaborative Professionals International Forum in Chicago. There were professionals from all over the world: Israel, Czech Republic, the UK, all over Canada. It's being practiced not everywhere in the world, but a large part of the world. And the reason is that, and you probably are thinking this already, it makes sense. It is logical, it is healthier, it's faster, and unfortunately not enough people know about it. We're working on that, so here I am today talking to you all, and you'll be able to say to your friends or anybody you know, there's a different way to do it. The two spouses should consider doing that. So that's who I am, what I'm doing. This is a conscious decision that I have made. I do not want to litigate. I changed my website last month. It now says, generally speaking, we are not going to handle litigated cases because they are destructive, they take too long, it costs too much, and it's not in the best interest of my clients.
Thank you, Bob. Thank you. I'm going to talk for a couple of minutes about mediation and explain to you how what Bob and I actually do can be very, very similar, but at the same time how it can be very, very different. Just a couple of things before that. Bob expressed some of his frustration with the litigated model. We're all frustrated with that. One of the best best metaphors I've come up with to get people to really understand how destructive this is I call it the Coliseum model. For me, it is each side hires their gladiator, the lawyer. They go to the courtroom, the Coliseum, and then they beat each other up and bloody each other as much as they can. At the end of the day, you have Caesar determining your fate, up or down, and you have absolutely no control over the process. And it works great in the United States legal system if the two people or the parties that come to the Coliseum don't know each other. Automobile accident cases, contract cases, all of these things are great in that model because then you're hoping justice will prevail. These are people, though, that afterwards don't have to deal with each other again. If you're hit, you're in a car accident, and you go to court, you don't have to deal with that person ever again. So you can beat the other side up and not worry about the aftermath and the fallout. It is completely ill-suited for the family paradigm, because at the end of the day, you're all still stuck with each other in a legal sense and in an emotional sense in order to continue to co-parent. So it's devastating and it's unfair, and all four of us believe that there are better ways to do this that really safeguard and take care of those relationships. At the end of the day, how you start your divorce process is how you're going to live your post-divorce life for a really long time. So if you go through it on the inside of it going in with a lot of contentious litigation, understand you may be condemning yourself to repeat trips to the Coliseum, because when somebody imposes their decision on you, one side or the other is generally not happy with it. And then they keep going back to court to get a better result. So not only is it expensive on the front end to get your final divorce, but it continues to be expensive and wear families down emotionally and financially for a long time after the final divorce decree, in modifications and continuing trips to the Coliseum. So this is why we're really, if it sounds like we're really trying to make this point clear, we'd like you, and when you talk to other people that are also involved in this process, try to get people to really recognize how difficult and damaging this may be and really think about the better ways that are out there to do it. Now, as far as how do I conceptualize what these better ways are, to me, the litigation model is taking public transportation. The only decisions you make in that process is when you get on it and when you get off it. You make the decision to start it, and then you make the decision when to get off. At some point, as Bob said, it will settle. 90% of them do settle before you get to your final hearing. The question is what you're going to go through and how you're going to get there, and where along this process that will be. Mediation is another tool in this arsenal. What Bob described for you is what I call the limousine. That's where you get into the limousine and people help you to get to that destination, but you're still telling them where it is you want to go. And for me, that's the best case scenario. The other option for people, and it's a viable option for people, and I'm putting this out there because I don't know what your circumstances are coming in. I'm not here to just sell you on one particular way of handling this, but to present a lot of information for you to think about ways you can handle it. Do-it-yourself divorce is now an option that a lot of people are considering. In those cases where there are not a lot of assets and there are no children involved, and you have a couple that really are savvy enough to go through some forms, people that aren't intimidated by, let's say, filing their own income taxes, for example, can actually download the forms, file it themselves. In Dade County, you have a self-help unit. You can go down there and take care of it yourself. And those are for, the cases that don't have a lot of complex issues and you're pretty comfortable that you can deal with each other and figure it out. To me, that's getting in your car and driving. You're in there, you're driving your own car, nobody's telling you what to do, and you can get to the place. Sometimes you may get lost along the way, and if you have a great GPS, you may find yourself back on track. But at the end of the day, you are going to get there, and if where you need to go is fairly simple, I think that's fine too. What Bob described and what I've dedicated at this point most of my practice to doing is that limousine model. Getting to that place, but having professionals help you along the way. So many of the things that Bob described are true about mediation as well. You save a lot of time, you save a lot of money, and it is private. Anything that happens in the mediation process cannot be discussed outside of the mediation process. We call it like Las Vegas. What happens in Vegas stays in Vegas, and you can't. There are exceptions, but for the most part, the process is confidential. And like in collaborative law, everything is agreed to before you ever file the first petition, before you file that initial document that gives jurisdiction to the court over the process. All of this is front-loaded and done in advance. How is it different? It's different in that rather than having two attorneys and the professionals direct the process, you have a trained mediator who is trained in family law, is trained in facilitating negotiations, who's neutral and impartial, generally does not know the parties or may know the parties, but feels objective about the parties. And this neutral facilitates a discussion between the parties, and the parties come to the agreement pretty much on their own. What are the major differences? When you have attorneys in the room, you can get a lot of legal advice. A mediator cannot give legal advice. What does that mean? If you have specific legal questions, a mediator can point you in the right direction, can tell you what the law is. But at the end of the day, the mediator is not going to be able to turn around and say, okay, spouse, in your specific set of circumstances, this is what I think you should do. To the contrary, the mediator will get the two to discuss it and agree to what they both think they should do together in order to remain neutral. You went over a lot of the benefits, so I'm not going to repeat it. The benefits are pretty much the same. I'm not sure you're aware, in Florida, every case is mediated before you get to a final hearing. It's something that the state of Florida has adopted. It's going on, about 20 years now in most jurisdictions in Florida? Yeah, probably about 20 years. Where if you want to get to a final hearing, a judge will send you to mediation. There are a couple of exceptions, like domestic violence cases where it can be waived if they feel it won't be beneficial to the parties, but to get to your final hearing, even if you go the traditional route, you're going to mediate. The question is, where along this continuum are you going to make that decision? And where do you get the most benefit of it? If you reach an agreement early and mediate early versus you're doing it only as that last hurdle you have to do in order to get your final hearing. Obviously, if you do it at the very end, you lose all the financial benefits of mediating early. And if you do it at the end, you also lose all that time benefit, as Bob just explained. A litigated divorce can go on 18 months, 24 months, and even now with the cloud court system, longer than that. So if you mediate early, obviously you save yourself a lot of time as well. Also, if you mediate early, you save a lot of the dynamic, that toxic dynamic that saves your relationships. Very often when the mediation comes at the very end, it takes the mediator hours just to move the parties off of that angry place that they've built up for so long and get them into a place where they can actually start to realistically negotiate something that's reasonable. So the process itself will take much longer if you wait until the very end. What I do that's different from what Bob does is I work with the couples through the process with no attorneys in the room, what we call pro se mediation. I will guide them through all of the issues that they have to deal with, the parenting plan, dividing the assets, the alimony issues if they come up, the child support guidelines, all of those issues. I maneuver them through that, and they'll come up with the agreement on their own. We do everything before suit is filed, so it's what we call pre-suit pro se mediation, as opposed to mediating during the process or towards the end of the process after suit has already been filed. So, and it can be done that way. I'd say the biggest difference between what I do and what Bob does is how much every hour you spend in mediation is actually costing you. There are cases where families have assets that need to be evaluated. A lot of psychological concerns involving the dynamic of the parents or the children. Those cases lend themselves best to collaborative law. And when I get those cases, even in my practice, when I screen them, I send those cases to people like Bob, and he knows this because I've asked him. Or cases that are very contentious and one spouse already has an attorney, I will refer them out to an attorney and say, you're not ripe for mediating in this paradigm. But for cases where the parties both pretty much know what they have, they pretty much have a good understanding of what the value is on what they have, they can deal with each other even if they are still angry, and even if there's still a lot of emotion to unpack, they can go through a mediation process where I will guide them through a and anybody who does what I do, we make a point of not just getting them through the process, but also teaching them how to better deal with each other and resolve their conflicts on their own. The goal of what we do is to get them to learn to discuss it, work it out, and make their own decisions on their own. At the end of the day, when you get the final divorce, if the process was handled the way it should be, the couple is much better equipped to continue to negotiate on their own and deal with each other. And they don't necessarily need the mediator or this big, great negotiation coach between them, and then they end up going back to court so much less because for the modification, they'll pick up the phone. If they want to deviate from a parenting plan, I'm sorry, I have a conflict, can you pick up, our child instead? They learn to pick up the phone, deal with each other, make the adjustments, and make the negotiations between themselves without anybody else really helping them. Less trips to court, less money at the end. A lot of people ask me who should consider mediating pre-suit and pro se. I will tell you it is not for everybody. There are a couple of kinds of cases I won't do. The first one that comes to my mind always is cases of domestic abuse or cases of domestic violence. I'm not going to say they can't be mediated. I believe that they can. I will say they should not be mediated pro se. I believe that somebody who's gone through that path needs an attorney in the room to level the playing field, whether they do it as a collaborative process or ultimately a litigated process, which unfortunately is usually the case. I think those people really should be represented through the process. Even with representation, it's a difficult thing to do for a victim of abuse. There are a lot of reasons, and I don't want to turn this into a session that deals with that specifically, but things to consider are, when you mediate, you need to be able to identify what your needs and your goals are, what it is that you think is best for you out of the divorce settlement, and what you think is best for your children. Oftentimes, an abused person can't do that and separate their identity or their needs apart enough from their abuser. So it makes it difficult for them to negotiate effectively on their behalf. And also, obviously, the amount of intimidation that was involved, or how long ago it occurred, how much influence is still being exerted over the victim. These are the things that go into weighing that out for somebody who's abused as to whether or not they should even mediate at all. As I said earlier, every case will be mediated before you get to a final hearing, but there are exceptions, and domestic violence certainly can be, the mediation requirement can be waived if somebody feels they can't do it or they don't want to face their abuser. The other case I don't generally like to mediate, especially not pre-suit. I would prefer to do it further along the line, is the case where you have two parties that have very different understanding of the financial aspect of their marriage. And this happens all the time. The typical case, although I've seen it in reverse, believe it or not, twice this year, but the typical case is you have the wife who has not worked and has been raising the children, and the husband who has the business or the job, and he handles the finances and she handles the home front, and then boom, you get to a point where they decide they want to divorce, and she has no idea where the money is, how much money they're making, whether she lived on an allowance or, just had the credit card to run free. In either case, you have one spouse who really does not know what the assets are. That can still be mediated generally if there's a very high level of trust between the parties. But in divorce cases, that's not usually the case. Once you get to the point of divorcing, that level of trust has been broken on one level or another. And I really strongly believe that those people, those parties, need a certain amount of a more formalized discovery process to put those documents on the table. Now, if they do it with two attorneys in a collaborative setting, they're still exchanging a lot more formal documentation of what the finances are. And they're doing it with the subspecialties, the professional specialties like a financial advisor or a forensic accountant to parse out and level the playing field on what the parties know about the marital assets and what they are worth. So those are the two main categories I say don't lend themselves to what I do for a living, although they can be mediated later on in the process with a lot of things put into place to take care of the parity between the parties. Then who should mediate? Pretty much everybody else can mediate. It doesn't even matter how much you have in assets or, are there a lot of 401ks or are there issues relating to the property. It doesn't matter how complex a case is in terms of its finances. It only matters whether or not the parties are pretty much in the same place in terms of their knowledge and can deal with each other fairly, respectfully. Even though there's anger, even though there's pain, they can still sit across a table and work out agreements because they're both looking at what's best for their future lives together and what's best for their children. And if they're putting their children at the forefront, as I also do what Bob does, I have them put a picture on the table of the kids, absolutely, so that they always remember what it is they're doing it for, what's the most important thing, and what is always the best arrangement that will be the best for the kids and make it easiest for them to continue to parent those children for a long time in the future. As far, just very, very quickly about how the process works, because I keep saying mediation, what is it? Mediation is basically just a meeting. The parties come together. I, do a little explanation of the process, and then we start the discussion. I throw out which issue we're going to cover next, and we'll explore what they've done in the past, how each side feels or envisions how they see their post-marital life in the future, and then we start fleshing out all of the agreements that Bob was describing, the parenting plan, the time-sharing agreements, and all of this goes together to create what's called the marital settlement agreement. You take that marital settlement agreement that's pre-agreed to, just like in collaborative law, and it's run through the legal system. When you do it pro se, it's not either attorney filing or bringing it through the system. When we're done with the process and we have all the documents, I also prepare all the other documents that are required to file the lawsuit, the petition, and all the other documentation. Then we give a complete package to one of the parties. Only one needs to file. The other one waives making an appearance, and that party will file in the self-help unit down in Dade County. There's a great program in Dade County. If you're in another county, I'll talk to you afterwards in more detail about other counties. They take all the documentation, they file it, they get you on the judge's docket, and then only that one party needs to show up for the final hearing. That process will usually take 4 to 8 weeks. The process of mediation, depending on the issues or how complex, can take several hours to several sessions, 3 hours each. So conceivably, the process is done in months rather than years. As I said, I'll stay afterwards if anybody has any particular questions about mediation. Now what I want to do is take a couple of minutes. We gave you the lay of the land, the litigated model, which, as I said, public transportation, the do-it-yourself, which is driving the car, and then the limousine. Family law is really the only place, though, where your public transportation actually costs a lot more than your limousine. Just a little thing to keep in the back of your head, but it's the truth. You give up, you have the least amount of control, and it costs you the most. I think I'd like to ask Judith Lieber to talk a little bit about Jewish Community Services and also some of the psychological components.
Okay. So I'm going to start actually with the family issues and then talk about Jewish Community Services. Because the reality is, whichever model that you choose, and of course I think that the collaborative process or any alternative dispute resolution is better than a litigated process, but the reality is at the end of the day, you still have to take care of the business of that marriage, which is parenting, co-parenting your children. And you will be doing that, God willing, for many, many years to come. And one of the things that, as a mental health professional, I want to avoid with families is a situation that Bob described, where you get to the place where your kids are getting married and the parents can't be at the wedding. Now, while that's a real shame for the parent, the real issue is the effect that that has on the children and then the grandchildren. So this is something that starts a history that gets passed down from generation to generation, and we want to really reverse that trend. One of the things that we know very clearly from all of the literature is that kids who come from divorced families will do equally as well. It's very important to remember this. They will do equally as well as kids who come from intact families if the amount of conflict is reduced. And I tell that to couples all of the time. You're worried about the effects that this divorce is going to have on your children. I'm telling you that the best thing that you can do for those kids is to minimize the conflict that the two of you are engaged in. And so having the pictures of the kids is crucial, because what I do is I'll hold up a picture and I'll say, you're saying that to him, but this is who's hearing it. Look who's hearing this. To kind of remind people that this is not just about them. It really is about their children. And the reality is that we know now that fathers are equally as important in the lives of their children, in the lives of their development, as mothers. So we used to have a process in this country where it was pretty much assumed that mom was going to get custody of the kids and dad was going to visit. In Dade County, actually, in Florida, actually, we don't even use those words any longer. So now we talk about shared time, and we talk about, we used to even talk about primary residential parent, and now we really don't even use that designation. So we encourage parents to think about ways in which they can actually both be actively involved with their children. Bob and Denise mentioned the parenting plan, and I brought copies of the plan because I think it's important for you to look at it and familiarize yourselves with it. I really do tell parents that God is in the details here. This parenting plan is 13 pages long, and as a mental health professional, I'm trained to go through every single detail with the parents. So in years past, we would say, okay, Dad's going to get the kids for this list of holidays in the even years, and Mom's going to get them in the odd years. So then you start to think about all of the different things that can go wrong when you just generalize that kind of statement that the kids get caught in the middle of. So for example, you say you're going to get the kids for Rosh Hashanah and you're going to get the kids for Yom Kippur. Really? Well, how is that going to work if mom doesn't drive because she's Shomer Shabbos? How is she going to arrange to get the kids from one place to the other in terms of the next scheduled visitation? So sitting down and working out every single detail is really crucial. The other issue is, in terms of parenting, there are different kinds of parenting that can take place after a divorce. You can have cooperative parenting, that's what we hope will happen. But in some situations, we really have to have what we call parallel parenting. So I'll work on a situation and say to parents, you know what, it seems to me that when you transfer the kids, when there's that transition, they're leaving dad and they're going to mom, that's when the two of you seem to get into more of a battle. So how about if you bring the kids to school Monday morning instead of bringing them home to mom's house Sunday night, so the two of you don't have to see each other right now? Isn't that a better way? The kids get to school, they go off okay, you go off to your work, and then mom picks them up from school. So we offer models that reduce the conflict. Always we're looking for ways in which to reduce the conflict. I'll talk to parents, if they're willing, to come in at the very beginning of the process and say, we haven't even told the kids. Now, I've had situations where parents have come to me and they're already separated and they haven't told the kids. And I say, you don't think they notice? And they say, what does every parent say? No, they really haven't noticed. You know, they're little, they don't understand. Kids understand. They're like little sponges. They pick up on every nuance of our feelings, of our happiness, of our sadness, of our depression, of our anxiety. So we want to teach parents how to negotiate and communicate with their kids in a way that's going to be healthy and productive. So I'll work with parents on what they're going to say in that first meeting with their kids, why we're getting divorced, what's going on. And even when they're little, you don't have to explain the details, but you do have to reassure them that this is not their fault, because kids will always think that it's their fault. Kids will always want to know, what about me? What's going to happen to me? You know, it's very nice when you say, you're going to spend some time with mom and you're going to spend some time with dad, and we're both going to always love you. Okay, let's talk tachlis. Let's talk a little bit about what does that mean, you're going to spend time with mom and spend time with dad. So I encourage parents to make sure that they set up space for the children in each one's home so that the children really do feel that they have a place. And I encourage the parents to cooperate, not because it's good for, I'll say, it's not good for you. It's good for your child to bring their favorite stuffed toy with them. It's good for your child if they have a special blanket that you share it back and forth. Because what's really important? That that child be able to go to sleep feeling healthy and safe and settled. So parents need to be reminded of that all of the time. The other thing that I want to mention briefly, and then I'm sure there are going to be lots of questions and answers, is that in every relationship, there's an imbalance of power. In every relationship, when you come to the divorce table, there's an imbalance of power. And as a mental health professional, in any of these processes, we're trained to help to try to reestablish that balance so that people come to the process of divorce feeling as though they have a voice, they can be heard, they can advocate for themselves, and they can advocate for their children. Because at the end of the day, when we get people through this process in a healthy and peaceful way, we've done a tremendous mitzvah for the entire world. I can tell you from a personal point of view that I don't want to work with litigated divorces, because for me as a professional, it is so toxic to be involved in that setting that I find myself saying, I can't do this. It's not healthy for me as a person. So, and I think we're all saying that. I think we're all experiencing that. So if we're experiencing that and we're somewhat outside of the process, what is it like for the people who are in the process? The other thing that I mentioned that I do is a parent coordinator, and that's a fairly new term, so I want to familiarize you with that because it's an important part of all of the divorce process. It started in California about 10 or 15 years ago. A parent coordinator is someone who comes in, usually post-agreement, after the marital settlement agreement is signed, to help the parties to negotiate the terms of the parenting plan and the marital settlement agreement, so that when they do have issues, because the reality is, after the divorce, although we'd like to think that everything is just lovely, it takes quite a while for people to settle down. It takes actually about 2 years for people to kind of take a deep breath and move their lives forward. So during that time, if they have an issue, as a parent coordinator, I give them the tools to be able to communicate with each other. So I will explain to them, you know, it sounds to me like right now, talking on the phone is not a good idea for the two of you. Maybe you need to just send each other an email or send each other a text. And so when I first started doing that, and I thought that was a really neat idea, I started to see these emails that were like toxic, horrible, 2 pages long with capital letters and bold, and I said, no, this is not what I was talking about. Let's go back to the table. So we talk about how to write a specific kind of email that gets the request about parenting done. Okay, I'm sending you a request. I need to change the parent schedule for next week. I'm not available on Tuesday. Will you be able to help me with that, or shall I get someone else? Now, getting somebody to that place is not easy, but what I do is I give them actual handouts of material that tells them, this is the format of the email that you're going to use. You're going to request information. You're going to put in there that you'd like a response within 24 hours so that you're not sitting there and waiting for somebody to call you back and you're kuching, you know, you're boiling because you're worried about what are they going to do. So we try to give people tools to use so that they can stay sane, stay calm, and stay focused on what's important, which is bringing up healthy children into our world. I look forward to talking with you some more and hearing your questions. Thank you.
Diana.
Okay, so I want to welcome everybody, and I hope that I can help you find some financial grounding during this rough or trying time that you're going through. If you're preparing for divorce, there are a few things that you have to take the time to do. You have to set aside a few quiet hours for yourself to think about your financial life before, during, and after divorce, and to pull out certain documentation that you're going to have to review or bring to the certified financial planner, and then call the certified financial planner, or CFP, that's what I am. And the reason being is that the CFP is governed by a code of ethics that demands that the person put your best interest in front of their own all the time. So at a time where you're feeling vulnerable, you have this person with you who's going to hold your hand and always be looking for the road that's going to be best for you, instead of trying to sell you something or talk you into something that you don't need because they're taking advantage. So it's really important, if it's not me, that it's somebody that has the CFP designation. Now, here are some of the things in your financial life that you need to consider when you're contemplating divorce. Income sources. What are your sources? What are your spouse's sources? How will each spouse be able to earn a living on his or her own? And does each spouse have a career to fall back on? And then we work on these aspects because it's necessary to have the income, the career to fall back on, to feel secure that you can bring in at least part of your own income, if not all of it. Expenses, bless you. What are our expenses? What special expenses will be coming up? Do we have to pay for camp or college for the kids? Do we have to renovate the house if we might be putting it on the market? Does somebody need a new car in order to be more mobile and be able to get to a new job, or to be able to shuttle the kids around more than they were before? How will the expenses grow and change if we're maintaining 2 households? And how will the expenses be covered if we split up? Debts. You have to make a list of all of your debts. And be sure to order your credit reports from Equifax, TransUnion, and Experian, or make your life a little bit easier by going to www.annualcreditreport.com. Because often when somebody's contemplating divorce or going through divorce, the other spouse may open up credit cards in the other spouse's name or may not pay bills. And you really, really, really have to avoid any bad surprises. So you're allowed one free credit report a year, but you really have to sit on this and maintain this and try to correct any situations that arise, because you really don't want to damage your credit reputation. Then, using the specific data about income, expenses, and debts, the certified financial planner will work with you to prepare a statement of cash flow. And you can throw at me, this is what I do in my practice, all kinds of scenarios. What if we sell the house? What if we don't sell the house? What if we rent instead? What if one of us gets a new job? What if none of us get a new job? What if our kids who are going to college get a scholarship? Anything at all that you could possibly think of, and we're trained to put it into different scenarios to calculate, what your future will look like, what kind of income you would need from a new job, what you can hope to earn, what kind of future you have, what you have to save to make your goals, and so on and so on. There's so many outcomes and so many ways to change outcomes. But then we take this cash flow, the income, the expenses, the debts, and we use it to prepare the financial affidavit, which is required by the state of Florida when you're filing for divorce, as well as to give to the attorney and the other parties involved in negotiating settlement. And this can change so many times, and a lot of times I give the ingredients to the attorney or to the mediator or to the husband or to the wife, and then they pull this information together, and maybe their CPA also helps them, and so on, and they come up with a proposal for a settlement. And then it goes back and forth, but all of this financial information is crucial in the settlement and in the documentation that's required by the state of Florida. What I also do is I also review the investment statements for inside the retirement accounts and outside the retirement accounts. I might work with the advisor, it might be the attorney, it might be the tax advisor, whoever is preparing the qualified domestic relations order called a quadro, which has to do with the division of the retirement assets and what's a fair distribution and how much income can the spouse who's getting the half of the retirement assets hope to get, and then what should they be putting away in their own retirement account, what can they afford to save, and so on. As well as how to organize the new investment portfolio, because when it's split into two for two people with two completely different living arrangements and living styles, it's different than when you're married and your assets are all put together. The CFP, the Certified Financial Planner, which I also do this, can act as a go-between with the Social Security Administration if you're doing divorce planning. What benefits can you get? What are your options in terms of when you should be taking these benefits? How does this income fit into your financial picture? Health insurance is another major issue. Which spouse has been providing the health insurance for the family? Should you choose COBRA? COBRA is the extension of your spouse's health insurance policy, but it's inordinately expensive. Or should you be looking for an individual policy? And the CFP, like me, can be the go-between between you and the insurance representative. How much can you afford? What kind of coverage do you need? Do you need to also cover the children? There's a whole bunch of questions that go into that. And as you grow a little bit older, you may also consider long-term care insurance, because now, after all, you're going to be living solo. So who's going to be taking care of you and who's going to be paying for this? Because now you're not a team to take care of each other. So now what? So it can be the go-between between you and the insurance rep to figure out what's really the best for you and also what you can afford to provide for yourself. Now, there are many, many tax implications that have to do with divorce. For one thing, you're most likely going to be moving from a situation where you're married filing joint taxes to a place where you're a single head of household. And the rates are different, and so on. Alimony is usually taxable. There's a way of structuring settlements where there could be tax ramifications or not tax ramifications. So the CFP can sit with you with the tax advisor and make sure that you really, really, really understand everything, what choices you should make, how to really fit all this into your new life, and can be an extra set of ears in the room, because if you're stressed, you might not be thinking clearly, you might be distracted, you might not really have a financial grasp, or just for that day, you might be going through a rough day and you don't have a grasp on what you're being told. So we want to make sure that you really understand everything. So in conclusion, going through divorce, as we know, poses many emotional, legal, and financial challenges. Divorce is costly, and no two divorces are ever alike. You might be talking with your friends about their situation, and what they're talking to you about is all gobbledygook. It has nothing to do with you, and your situation has nothing to do with them. So you really need to have a certified financial planner on your side. You shouldn't delay, because there's a lot of services that we can provide to really help you feel more confident and secure, at least about the financial transition to your new situation, to make sure that you really understand what you're getting into and hold your hand through the process. I look forward to hearing your questions afterwards, and thank you very much.
Thank you. That was a lot of information that we just threw at you really, really quickly. So we decided we were going to give you a little time off to kind of process and digest and put together some questions. There's, some snacks, and we'll take a few-minute break. Before we do that, though, just a couple of little things that were touched on by this group that I want to flesh out. And one thing that I think is important that we kind of missed, that I think you need to know. If you are in Dade County, well, in Florida, there are a couple of classes you're going to need to be aware of that you're going to be required to do in order to divorce. One is actually the parenting.
If they're minor children.
If there are yes.
The class.
Yeah, if there are minor children in the household, there is a parenting class for the parents. It's about 4 hours, and most providers will provide it for you online. If you walked in, there's an information sheet, and it has those websites where you can get that information. If you're in Dade County, there's also another class called Sandcastles. It's broken down by age: young children, slightly older children, adolescents, and then preteens and teens. It's broken down into those categories, and it's also, I believe, a 4-hour course. It's offered in a few places. I think FIU is one of those places. Miami-Dade Community College, where you would be required to have your child complete that class and present a certificate of completion in order to divorce. So those are just two things that if you're in Dade, you've got both the child's class and the parent's class. Anywhere else in Florida, at minimum, you do have the parenting class to take care of, and there's more resources, and you can figure out based on what county you live in whether the Sandcastles is also something that's required for you. Also, just very quickly, Diana touched on something called a quadro. That's a qualified domestic relations order. That's for people that have retirement accounts that are not easy to break without penalty. If you have an IRA or a 401k and you've been putting money aside for your retirement, what has accumulated in that account during the marriage is a marital asset. Even though you think it's your job and it's your 401k, it's part of the marriage, and sometimes it does not make sense to just cash it in and separate it because you lose too much. So there's another way where a financial specialist, whether it's an accountant or a financial advisor, would draft an order for the court to show the court how this will be separated out at some point in the future and how much each person is entitled to out of that account. One other little thing also that we didn't mention that we probably should is, in the event you have a will, that's another element that you may want to change, and think about how you would want to change that in preparation for divorce. Obviously, if you have a will that was taken care of by an attorney and that attorney represented you and your spouse, you may want to rethink it and find somebody else to redraft it for you, depending on how comfortable you are with that lawyer who did it. And that's obviously one of those questions you're going to raise with whatever professional will help guide you through the divorce process, and they could probably send you on to another professional to take care of that. Yes?
When you're finished, I just want to add one thing.
Sure, absolutely. I'm finished.
Okay. So you very kindly asked me to talk a little bit about JCS, Jewish Community Services. So I did want to tell you a little bit about us, because we're co-sponsoring this. JCS is one of the largest social service agencies.
What does it stand for?
Pardon me?
What does it stand for?
It stands for Jewish Community Services, and we are one of the largest social service agencies in the state of Florida. We've been in existence for almost 100 years. I haven't been there for all that time, although sometimes it feels like that. We provide an enormous range of services. I'm responsible for all of the counseling and case management services for the agency. We have about 30 programs that serve the Jewish and non-Jewish community. We also have a home health agency. We have a rehab and employment division, a senior adult division. We have programs for domestic abuse. We have programs for at-risk kids in the schools, in the day schools, a range of programs. We work on a sliding fee scale. We're partners with Greater Miami Jewish Federation and United Way, and I have a highly trained, dedicated group of mental health professionals who are available to work with you through any of life's transitions. So I look forward to answering any other questions that you may have. Thank you.